Hola amigos y bienvenidos al expediente semanal.
Hey guys, good morning to all the places you're from, and here in the chilly Raleigh area, but it's going to get warmer, I think. Got some congestion here from the change in weather, but we got some cases to talk about, so let's get into it because it's going to be kind of interesting, I think. Let's see if I can switch this up. All right, this came from the chat this morning before we went live, so if you were there, you know what I was talking about. This is a Texas in the 80s. So anyway, let's move on past that, but that was fun. Hello to Central Florida and Scotland. Glad to see Scotland checking in because I certainly get asked that by my wife all the time. And when are we going there? In Florida, of course, I've been there many times. Her family is there. Nashville music situation happening there, of course. That's awesome. All right, here's Darrell Brooks. Poor guy's just not having any luck in the legal system, and for somebody with as much experience and knowledge as he has, you think he'd be riding a smoother path, but no, it's not working out for him. I don't know if you can read this, but it doesn't really matter because I think everybody knows that his previous status in court was to get a counsel update. That was going to be Halloween, and he was supposed to be appointed counsel by the public defender's office, and it didn't happen. So now it's been moved out to December 14th for a status of counsel update. Now, I think sometimes people think something big is going to happen at this hearing, like there's going to be testimony and stuff, but not really. This should just be when it ever does occur. Hey, he got a lawyer appointed, and the lawyer tells the judge, I'm ready to go to trial, or I want to do this or that. You know, I also understand the viewpoint. Why do they keep going on with these charges? But I think Erica wants to pursue these, and that's fine. You know, it is what it is. He's been appearing by Zoom, so it's not like he's getting a big lift out of this. And they don't seem to be in a hurry to get him an attorney. Isn't that weird? Months and months go by. I don't know if they proposed one and they can't settle on it, or nobody wants to do it, or he's at the bottom of the list for people they care about, or whatever. So we will see. Welcome to Indiana, home state of David Letterman. Georgia. That's where the devil went down there, but it didn't work out for him. He was looking for a soul to steal and ended up losing that bet. And you can lose a lot of things in Georgia, so if you're not careful. All right, so that was Darrell. Poor Darrell. You know, he's not making the kind of news he'd like to make. Nothing really happening on his appeal last time I looked. But things are looking up for, kind of fellow compatriot in terms of feeling put upon by the whole world, Sarah Boone, who has a lawyer now that she's kind of stoked about. And Mr. Hobson appeared in court and told the judge that he would like to have a status conference in January of next year. And he wasn't going to be ready for trial then, but they should be able to discuss then when they could go to trial. And Sarah actually nodded her head yes to this and smiled at the attorney and shook hands with him. So she's stoked about this guy. Is this the one? Is this the one who's going to get her to the finish line? Have they had a discussion yet about whether he's going to be able to push her battered partner syndrome defense or get her a new expert? You know, it seems to me that likely that the experts they had didn't give her the testimony that she wanted or the opinion she wanted, because her last attorney before he withdrew was trying to get a new expert into the case on this topic. She's already had prior experts. Will this guy follow up on that and ask the court to pay for a new expert and push this defense? I guess we'll have to see if something happens. The judge asked him not to wait until January to do something if he needed to do it, if there was a discovery issue or something like that, which I don't think there's any fights with the state on discovery here. This is all about her wanting to get somebody to testify as an expert that she was a battered partner. And why would they do that? Why would she need to do it? Well, there's some sorts of things that you need an expert to put in front of a jury. like if you find DNA at the scene, the cop can't just sit there and go, well, we found his DNA, so that he's guilty. And then the defendant goes, well, not really. That DNA doesn't work like that. You need an expert, okay, for that kind of topic. And for this kind of battered spouse syndrome, you put the expert on the stand to explain it, talk about it, maybe talk about how she has it or doesn't have it, because she's probably not going to testify. And then they may be a competing expert by the state and back and forth and all that. So, yeah, she doesn't want recycled experts. That's for sure. That's a comment here. Absolutely. So, all right. So, somebody said about on mute. I don't think I'm on mute, though. All right. So, yeah, so she's got the new lawyer, and that's good news for her, I suppose. So let's step off. There'll be some action in this case that you watch, because he's going to do something, I think. Seems solid. And if he's going to push her defense, he may need another expert, and can put that forth to the judge. So here's another recommendation for Scotland. Who couldn't recommend it, right? I agree. So, all right. Now, let's go down to South Carolina and talk about Murdaugh, who is still keeping some action happening in his case. And they're not accusing of Judge Newman of doing anything wrong in a trial, but they are accusing him of doing things wrong after the trial, or after the verdict at least. And they don't want him to hear the motion for new trial or any other cases involving Alex Murdaugh. And while most people I appear on panels with think they didn't either prove the case against him or he didn't do it, I'm of the opinion that he did do it. That's my opinion. So having said that, I agree that he deserves this hearing for a new trial, and maybe deserves to have it heard by somebody other than Judge Newman, because Judge Newman may be personally involved in the facts, not that he was responsible for the alleged conduct, but if he's mixed up in the middle of it, that's, kind of a fair point they're making. And I think they're making a fair point that probably someone else should do the other trials against him based on what was said in interviews and things like that. So the commenter was on mute. Okay, good. Because I did put it on mute the other day, and that was stupid. So here's part of the brief that Murdaugh's saying, look, you can't hear my other cases because you've already said out in public how terrible I am and how guilty I am. You commented on the case, and you have this opinion of me anyway. And he's filed a writ of prohibition in the Supreme Court of South Carolina, saying Newman should not be handling my motion for new trial. And they talk about the fact that the judge, again, is potentially personally involved in some of the facts of the case, but also that the judge commented on the jury verdict, which I guess you're not supposed to do. And I looked up the rule here, and you're not, but there's really not a penalty for that per se. But also that he gave interviews after the case was over. And certainly during sentencing, the judge can talk about how disastrous of a person you are. But also, as you know, Newman gave interviews after this case was over and talked about it. So they're saying he shouldn't be the guy looking at the new trial motion for me because his involvement in the facts and all these things he said and stuff like that. So I can see that point certainly by them. So Harpootlian's still on the move on this case to try and get Murdaugh out from under his murder verdicts. So we'll see how that works out. If this has to go to trial again, what a mess, right? What a real mess. And you can expect the defense would fine tune their approach there, and the state would try too, but you only need one a juror on the defense to keep from getting a guilty verdict. So we'll see what happens. Is this thing? Sorry about that. I think I'm getting spammed ever earlier in the morning. So let's go to Kohberger here out in Idaho. And that's where there's not so much drama, and people have to imagine drama for the case because the judge is doing such a good job, I think. And the attorneys for the parties as well, and the parties actually. Kohberger's not doing anything crazy while he's in custody or appearing in court, and his attorneys are being, in my opinion, very professional. The state too, and the judge, and this is really how I think a case should go. So we did get the news that the FBI was out at the house again doing some modeling inside of it. Now, an interesting thing that I picked up on that was that they're not just modeling the interior, but the article said also that they were doing audio experiments, which is interesting, I guess, because part of this will be, well, who could hear what, how would things sound, because there was some sound captured outside. And that's relevant to some degree. But it's not in question that these people were murdered in this house around a certain time frame. So I think maybe this would be about people in the house and what they could hear and stuff like that, as the defense might contend that some other scenario other than Kohberger occurred, which that's certainly what they're going to say. And so, the better and more accurate picture you can paint if you're the state, the better, and potentially for the defense as well. They weren't going to do this originally, I think, because they didn't have time when he was going for the speedy trial. But since that's off the table, there is time. So it's not a conspiracy or anything terrible or anything like that. And potentially, of course, this house might still be available for a jury to have a view of it if a party requests and the judge decides that's the right thing to do. Sometimes they do, sometimes they don't. But I don't think they're going to demolish it until this case is over. So we'll see. Can I believe, I got to look at these comments, man. Can I believe the Alamo doesn't have a basement? I can believe it because when I went to the Alamo, it was not what I thought it was going to be. It really was, it was really a lot smaller. So, all right. I'm not sure how that came up, but that's pretty funny. Okay, so that's what's going on in the case. It's not, again, there's nothing really wrong with this, right? And how the judge is handling the case in terms of the family genealogy, the DNA research there, the cameras, stuff like that. He's just doing a good job of being balanced, I think, and listening carefully to the arguments by both sides and trying to keep the case on track. And the attorneys, not every argument either side is making is great. Some of them are really bad. Some of them are really good. But it's being professionally done, I think. So it's not so much theatrics. And there's the layout. I also pulled out an article there. Of course, 2 of them were on top and 2 on the main floor. And then the 2 survivors were at the bottom of the house. And of course, I think it'd be interesting for everybody to be like, well, what did they hear? Because we know they reported, or one of them at least reported hearing some things being said and some sounds and stuff. So we'll see. Now, this case, of course, is a total disaster right now. I think it's just a disaster, whether you think this guy's innocent or whether you think he did it or whatever. It's not good. And of course, talk about the murders of Libby and Abby when they went for a hike on this bridge. You can see the picture there. It's a picture from that day and shortly before they were abducted and taken to be murdered. And the person who abducted them on the bridge, despite conspiracy theories that that's a fake video and all that, that's nonsense. That's who it is. Who is that? Some people think it's Richard Allen. Some people think it was Ron Logan. Some people think it was somebody else. I don't know. I think I'm in the camp to agree with people who go, you cannot tell for sure who that is or even what they have on them. I mean, it looks to me, watching it, that there's clearly things in the jacket besides a person and maybe supplies that the person brought to do what they were going to do. And then maybe not. I might just be seeing things. But this is a disaster that's going on. So I'm going to have some documents I'll pull up, but I just wanted to overview it quickly before we get into the legalese. So the judge says the attorneys withdrew. Was that effective? I mean, they're saying that in chambers they were told, if you don't withdraw, I'm going to come out and make this statement, which in the heat of the moment they took to mean not only would it be bad for them, which wouldn't be a reason to withdraw, but it would be bad for their client, which would. And so they acted under pressure from the judge. But the thing is, one of them allegedly said, okay, I withdraw. And the other one said, well, I'll file the paperwork. I mean, if you say, well, I'm going to buy this and you don't pay for it, have you bought it? Is this a contract? Is this an agreement with the judge? Can you back out of it? I mean, this is all very bizarre because Rozzi never did file his withdrawal paperwork. If he didn't need to file it, why was he going to file it? And if he needed to file it and didn't file it, did he ever really withdraw from the case? And then for Baldwin, was his withdrawal, since it was outside of the rules, certainly, was it effective? And even if you withdraw from the case, can you come back into it? I mean, maybe the judge doesn't agree to appoint you as paid counsel, but see, go to the second bullet point where the attorneys agree to appear pro bono. So Allen says, I want these as my guys. And they're saying, well, judge, you don't have to appoint us and pay us through the state. We'll just do it. And she says, no. Wait, what? And then she says, I'm not going to allow you to do it. And I think that her order says, I have a picture of the written version of it in a minute, that, her grave concerns are because of their gross negligence. And see, here's the thing. If you're going to sanction an attorney or whatever, I mean, normally you would have some grounds in the order. Like you would have some facts, like you didn't do this discovery despite a prior order. You failed to turn this over. You refused to answer questions in the deposition. You breached this order of confidentiality, whatever, like these findings of fact. and then the conclusions from that and the decision of what the judge is going to do. Like, I'm going to sanction you this way or the other. And usually you don't go from no sanction to a nuclear option, which say in a civil case, maybe in a criminal too, if you threw the case out, the judge might strike your complaint or strike your answer. Like, say that's what happened to Alex Jones, whether you agree with it or not, that is what happened. So the liability was conceded by that. Well, that's kind of a nuclear option, right? So the judge kind of nuked Allen when she said, well, you can't have the lawyers you want. So how did you go from this to here? Now, I'm not saying they did everything right or that she didn't have grounds to potentially sanction them or even do what she did. And I think on the discussion yesterday on a panel, Kurt saying is it's all in the abstract because what's the record on this? And we don't know it because whatever occurred was done inside of her chambers and there's no transcript of that yet. So if you make an order, but you don't put any findings in it, how can an appellate court review whether you acted inside of your authority as the judge? So typically you want to bulletproof your orders to make sure they have enough information in them. If they go up to appellate court, they'll be sustained. And I don't think so here. And for example, what's the gross negligence? Are you saying these attorneys are incompetent to represent Allen? That they're not good enough to represent him as defense counsel? Well, what's the basis for that? I mean, even the leaked pictures, let's say they did that on purpose. And I'm not saying that that's terrible, but that's not bad for him. Okay. It's not bad for him that they're presenting this Odin thing because they've got people to think about other things. I mean, it may not be the best idea or it might be or whatever, but surely they're acting on his behalf. I mean, these guys are believers, right? They want to try to get him off. So I don't know that this gross negligence is incompetence in terms of handling the defense for his benefit, which is primarily what they should do. Is it gross negligence in complying with prior court orders to the point that you're sanctioning them essentially to get off the case because they won't abide by orders? All of that should be in an order somewhere. It should say, here's what they did, here's what it violated, and here's why I conclude it's to such a degree they have to be off of the case. Yeah, the leaks hurt Allen. He did it on purpose. I don't. I think if you think that, then if you're the judge, that should be in the order, right? And I don't, because I don't see it in the abstract that that's true, that they were that they weren't effective as his defense counsel, and especially if you compare that to what his new defense counsel is trying to say. So, so let's keep going off of these bullet points before we get into the actual evidence here. And then the judge says, well, you know what? Since you said you want to stay in the case and you want me off the case, I'm ordering the clerk to strike those. I'm striking those, and I order the clerk to remove them off of the record. That's a touchy, dicey subject. I mean, there are some times when that can happen, and most of the time when it cannot. And I don't think the clerk did it. But is that the right way to even handle all these other things that the attorneys brought up? Why wouldn't you address that and just say, because of previous removal, this is denied, or whatever, will not be considered? Why order all this stuff struck? People saw it already anyway. It doesn't look right to me. Now the judge is facing a mandamus action that we discussed last week, and she's got her own lawyer who's asked for an unopposed 5-day extension of time, which is reasonable, to help her argue to the Supreme Court on why what she was doing was the correct thing to do. Now, as you'll see, and you may already know, she's facing another original action that's going to go up to the Supreme Court from another lawyer for what she's doing. So there are in excess of 10 lawyers involved in this case right now, and the story is the procedure and not the facts of the case, and that's not how a case should be. That's bad for the defendant. That's bad for the victims' families. It's not good. And then, of course, she appoints 2 new attorneys, and one of them did have some discipline action. I'm not sure it's totally relevant to this. I don't even think it was from the bar, but the other one gave interviews on the case. I've heard some people say that he said in an interview basically that the state has the case against him. If you heard the interview I didn't hear that, but I did hear him commenting in a way that you could interpret as favorable to the state's case, that the ballistic information could be there to match the gun to the round that was found at the scene that was his gun. And I don't think a defense counsel is required to say that's never going to apply to a case. But on the other hand, when you're pretty favorable about it and you're like, they probably have more evidence that they hadn't put into this PCA, would that be the guy who said that on TV that you'd want to be your lawyer? Not in my mind, right? Here's a question. did she remove their motions filed prior to removing the attorneys? I guess that's all on the timing thing. In terms of the Franks motion and the motion to, I think, get rid of the forensic evidence or the opinion on the case cartridge match, those are still pending. And she said the new lawyers can decide whether to continue those or change them or whatever, and they have to look at them. But in terms of after that Chambers meeting, she said she was striking what they said. So, but I don't know that didn't appear to actually happen. And yeah, so she has her own attorney after the state denied her counsel. That's correct. Somebody says in Indiana that a judge can remove anything from the record. So, and like I say, different states are different ways. And there's kind of a couple things here. One is actually telling the clerk, take this document there's taking the document out of public view and putting it where not everyone can see it under seal. Then they're saying, take this document and get rid of it like it never happened. And then the third thing is remove it off the docket like it was never filed in the first place. So those are all discrete actions. And what the defense side is saying is that if you want to put things under seal, then there's a process that Indiana law requires you to go through. And you haven't been doing that in this whole case. And so that's an argument they're making. And I certainly understand where they're coming from, but I'm not an expert on it. So I take what you say into context there, because I agree that there are some times when that can happen. But I don't think it can be for no reason at all, just because you feel like you don't want anybody to see that somebody's trying to show your judicial misconduct, which is kind of what they're alleging, that you can just go, well, let's just put that in the shredder. So that's interesting. Somebody said it was an order for the clerk to remove it from the docket, and she doesn't have the power to do that. Right. So that's an issue that's being brought up. So that's weird. And last time I looked, it was still registered on the docket. I don't know if the documents were available or not. Anyway, she's got another action coming, and I think this will be about. So the first action is really about how she handled the confidentiality documents and about striking the documents, because if they won that from the Supreme Court, that would put them back into play and their motion to disqualify back into play. But the second original action that's coming up, I think, is going to try and encompass the fact that she ruled on the 31st and apparently somehow on the 19th that these guys couldn't be in the case. So there's a lawyer who's handling that and hasn't filed yet because this lawyer says the transcripts had to be prepared and has filed something for that and is requesting a transcript not only of what occurred on the 31st, but the in-chambers hearing on the 19th or meeting or whatever they're going to call it. And that's where the rubber hits the road in terms of, well, what happened in that chambers meeting? Does it support what the defense is saying, the judge is saying, or whatever? But either way that goes, if the judge is going to rule that you're out of the case rather than saying that you withdrew from it, but actually say you are off this case, you can't come back, that, in my opinion, needs to be by order that is substantiated by findings of fact and conclusions of law, like an order should be, such that an appellate court can review it. And if all you do is say, I think they're gross negligence, so I'm not going to let you back on this case, I would question whether that's sufficient enough, even if she were correct, and I'm not saying she is, to survive an action at appellate level, because the order doesn't seem detailed enough to support what you're doing, whether you actually had the facts behind you or not. All right, let's see. Okay, I was looking at some comments here, and so somebody says that this is outside the scope of her duties and she'll be forced to recuse. I would, if I were betting, I would go with you on that one. I don't think this looks good for keeping the same judge, the odds wise. So here's a bunch of stuff I got on another screen because I can't really read it. But on the left side, on the video that I'm doing the stream on the side of the case where I'm at is the text of the judge's order. And that's where she talks about that they have that the court previously found gross negligence by said attorneys in their representation of the defendant. Nothing's changed in the intervening 12 days. That removes the court's grave concerns over their strenuous objections. The court disqualifies them from representing the defendant. So is that order, if you were to appeal that order, which they're kind of going to do through these actions, and if he were convicted, he certainly would do, is that order detailed enough that the appellate court can go, well, we're able to see why the judge did what she did and what authority she exercised, and we can judge whether, her conclusion was within her discretion or within the law. Is that got enough information in it? That's not how, if I were a lot of times in court, especially in civil practice, if you're going to win the motion or whatever, the judge will ask the side who's winning, will you draft up an order? And then you do it, and then the judge will sign it. I mean, the other side can object to it or whatever, but the winning side will do that. And one of the things you want to do is make sure it has enough information in it that if the other side appeals, that you won't lose there because your order sucked. Okay, you won on the merits at the hearing, but if it's not substantiated in the order, you could lose on that basis. And to me, this order is insufficient regardless of the underlying facts. And then I think the underlying facts, I have not heard things that, in my mind, that would support kicking these lawyers completely off of the case as a first instance of discipline. So we'll have to see about that. And then, of course, now there are new lawyers or on the case, and there are some issues with that. And here's a couple of quotes from one of them. It's not a death penalty case or life without parole case. It's just a double homicide, which we do routinely here in Allen County. The only impact it will have is the travel time to another county. So, this is kind of weird, too, because you're appointing defense counsel that's over 2 hours away from where this case is going to be held. Of course, the judge is, too, but that's something. And the other thing is they say it's not a death penalty or life without parole case. And I have seen some people say, what? How can they say that? So if you look at the top right of the screen here, assuming I'm oriented correctly, anyway, the statute that's up there are the punishments for murder in Indiana. And the sentence is between 45 to 65 years when an advisory sentence of 55 years. However, the state can seek the death penalty or life without parole under certain circumstances. The little box below that is the statute that tells how they do that. And they have to allege in a document separate from the charging document that they want either the death penalty or life without parole. And they have to allege the existence of an aggravating factor that would support that. And I don't think that's happened in this case. So I think this is why this lawyer is saying it's not life without parole or death penalty. On the other hand, if you're on trial for 2 counts of murder and they could be consecutive, that's your life. And if you get a 65-year sentence and you're Allen, that's pretty close, right? Death penalty would be something different, of course, but this case is pretty serious. It's not just a double homicide. I thought that was an interesting way for him to put it. And then he talks about they have a good relationship with the prosecutor so far. And I don't doubt that, because McClellan probably would like to have a collaborative relationship with the defense that didn't involve all the allegations the defense was making against him, the other 2 guys, whether they should have been making them or not. So that doesn't cut in their favor either, in my opinion. So just want to explain that in terms of the law about his comment there. But down at the bottom, you see Fort Wayne attorney gives insight into Delphi developments. So this is the other attorney, and he's done a couple of interviews on this TV station talking about this case. And to some degree, he's just given, hey, this is how the procedure works. This is what could happen. They might move for change of venue. But they did get into a discussion of the forensic evidence in the case in terms of the match based on extraction marks of the round that they found. So, and that can be an issue. Like, I don't know that he has to agree that, he could have said, well, that's never true. It's all junk or whatever. And because that's in some people's position, but it's not everybody's position. And it is not the law in Indiana. So he could say that, but you're fighting a losing battle at this point, because the Indiana Supreme Court has said, no, this can come in. However, if you're talking about, they can match this up, not all the time, but a lot of times they can match it up, and there's more evidence that may not be in a probable cause affidavit. I think the people who say that his commentary seemed to be favorable to the prosecution have the right side of this, right? So if your lawyer has been on TV talking about your case before he comes on to the case and has said things favorable to the other side, if you were picking a lawyer, would you pick that lawyer? I mean, what if jurors have seen this or do see it? Yeah, I heard the guy that's representing was. I mean, there are a lot of people on the internet who saw this interview who take it to mean that he thinks the state has a better handle on this case, that they're correct. So that's not an impression you want to give if you're the defense lawyer. So I think it's fine that he gave these interviews, but it's kind of bizarre that he ends up appointed on the case. And of course, that raises the issue of people like, well, maybe the judge are picking these guys on purpose because of how they feel about this case. And I don't know anything about that. I'm not suggesting she did that. But when you blow up a case like this and you pull in the original attorneys off a couple of months before trial and you appoint out-of-county attorneys, some of them, one of them of which has been on TV talking about this case, you get this kind of thought process going. And I can't say that it's unreasonable to wonder about these things. Yeah, rare to get a death penalty. And the thing is, if you're charged with felony murder like he is, if that's what they prove, there's also some additional hurdles you have to do in order to get the death penalty. It's still potential under Supreme Court rulings, but it's not like a regular murder case. So I can understand why they wouldn't do that. But however, it's kind of interesting they're not going after life without parole so far. So whatever on that. And I think they haven't had somebody executed in a long time. I did a video on it a while back and tracked that, but whatever on that one. But I just wanted to really explain why his comment legally was correct, even though it seems kind of tone deaf to the situation. So this is pretty whack here, isn't it? Isn't this weird? And then you have, here's the judge with her lawyer appearing, asking for additional time to respond. So she, I think, wanted the Attorney General's office to represent her, and they didn't do it. And now she has a lawyer helping her respond to the mandamus motion, or writ of mandamus that was filed. Okay, so now you got the judge with a lawyer. You got Allen with a whole lots of lawyers. The state has their lawyers, and now the judge has a lawyer. This isn't how it should be going, right? Especially when they were only a few months from trial. Like, let's put this on trial and see if this guy did it or didn't do it to the best that, the system can provide that answer. And then here's some paperwork for the new potential original action. And you can see they're asking for the in-chambers proceeding from the 19th. So they want a transcript for that, as well as the hearing and the 31st. So that's pretty material there. I think everybody would be interested, and you won't get the tone of voice, but you at least get what was said. Everybody's interested in what got said in that. Now, having said that, while I was equivocating on that a while back before we got past the 19th, in terms of, did they withdraw? How do we really know? Well, we'll learn some of that, but I think the actions after that are not well supported by the court, and let's put it that way. And that could lead one to conclude that maybe what happened on the 19th was in the same vein, and it's more to the defense side. So, well, they need to define speedy trial better. Yeah, I mean, they have, once you waive it as a defendant, then you're up to the vagaries of the system. And of course, he had a trial coming in January, but sometimes they get delayed, and that's how it goes. Was that warranted here or not? Yeah, I don't know. I'll say, well, this lawyer, I think this is this person's Twitter account, and that's, in a case, it's headed to Twitter, so that's bad, but the statements are not crazy or anything. They're right in line with the ideals of the law. Deprivation of the right to counsel of one's choice is complete when the defendant is erroneously prevented from being represented by the lawyer he wants, regardless of the quality of the representation he received. Okay, so the error is structural, meaning it affects the entire proceeding. Violation occurs at the moment the defendant's choice of counsel is wrongfully denied. And this is my point, that if the judge is wrong in this and it goes to trial and he's convicted, let's say he's absolutely guilty. He just did it. There is a confession, and then they find more evidence, and he obviously making things up, but let's say it's just anybody who watches it goes, well, yeah, it turns out he actually did it. The case can be thrown out because of this. And you want your case to be decided on the facts of it, right? If there's not enough evidence to convict him, you don't want him convicted. If there is, you want him convicted. You don't want the case to be upset by things that happened before that occurred. So that's a big problem with this. Often the most important decision a defendant makes is in shaping his defense is the selection of an attorney. And where a defendant is able to retain counsel privately, the choice of counsel rests in his hands. So see, when they say, well, we'll do it pro bono, you don't even have to pay us. So they put their money where their mouth is. And she said, I'm not going to let you do that either. You can see a lot of attorneys rally to the side of the defense here and said, we're willing to step in and take this up to the Indiana Supreme Court because the judge should not be doing this. And now it puts the whole case at risk. It takes the litigation off the path of getting to the trial, which is what the victims' families deserve, and it's what Richard Allen deserves. And now it's delayed, and now it's also subject to all these actions. Because what if the Supreme Court comes back and says, nope, you can't strike any of that stuff. You need to consider these motions. Nope, you can't take these counsel off. Then they come back on, but the case is delayed. At that point, can she be the judge on the case anymore? This is very weird. This is very weird, and it's a terrible way for this case to be going right now. And this whole thing is awful, right? They didn't find this tip from Richard Allen until years later. It wasn't new evidence. It wasn't somebody else that called in and and they look back at it and go, you're right, it was him. They just found it. So people were skeptical over that. And now you have all of this action happening. So this is bad. This is very bad. There's no discussion of the facts of the case really here. And in my opinion, these attorneys don't have to do that. And notice this attorney is not saying, I can prove it was Ron Logan on the bridge. They're talking about how the trial is conducted, which should be important to attorneys and people in general, that there's a process to be followed. You don't shortcut the process. You don't change it because you think somebody did it or didn't do it. You have a process. And so that's why I say, I think, in my mind, I'm with the defense on a lot of this, even though, I view the circumstantial case against Allen as pretty good, not enough to vote against him until you see the evidence and things, but I'm not convinced he's innocent, but I am convinced he deserves a fair trial. And I don't see it supported that his attorneys should have been removed from the case like this. So I guess we'll see. That's just my opinion. Like, I wouldn't have kept him into prison either. I think I would have been convinced that he couldn't be accommodated in jail because he's not been convicted yet. So let's see. Pressure on law enforcement right before an election. I understand that argument. And the thing is, when you have so many anomalies occurring in a case, your skepticism begins to grow, right? And you start to give other things even greater weight because this is all bizarre. But I don't think it's a giant Odin conspiracy that involves the two new defense attorneys, the judge, the Indiana Supreme Court, everybody, everywhere. You don't have to think that this is incorrect for how this is being handled. I'm not saying you said that, but I'm saying that you can look at this incident and see, why would the judge do what she's doing? And, you can see a giant personality conflict occurring between the defense counsel and the judge, and her getting tired of them in her view. You didn't control this evidence right and stuff like that. And maybe they didn't. But again, where is it on the record that they did this, this, and this, and therefore I'm discharging them out of this case, and here's the authority I have to do it. So, we'll see about that. Somebody says keeping Richard Allen in prison has caused automatic appeal. Well, he's certainly going to appeal, and if he's convicted. He may not be convicted, of course, but if he is, he might add that to his list of arguments of why he was not able to mount his defense. We'll see. Somebody says, I'm not buying Odinism, but something doesn't seem right here. Yeah, I mean, that's weird, right? And, the allegation that he confessed while he was on the phone, or tablet or whatever to his wife. Nobody really knows what that is. Here are so many bizarre, and why did he do it? So many bizarre things in this case. Yeah, the guards were wearing at least pagan patches, and I think one of them was directly toward Odin, at least one. And that's weird. It's all weird. I concede every bit of that. This is really, more. I don't like to imagine things, but this is then. Oh, well, that probably didn't happen, but then it did happen. And thinking, well, the judge is going to force these lawyers off the case, even if they say, let's take the temperature down. We want to get back in this case. And remember, Baldwin's lawyer said, Judge, if you need to sanction somebody for what happened, sanction me personally, because I was supposed to have control over the evidence that I had in my office. If I failed in that duty to the degree that you think punishment is warranted, punish me, not my client. That's the way you should handle it as a lawyer, right? And why didn't the judge do that? And of course, in her view, because I guess the totality of things was already so bad that they were irredeemable for her. But that's a pretty extreme conclusion to reach. And I would have asked to have that supported in the record, or thought to support it in the record. We'll see what happens with it. But she's attracted a lot of lawyers on this who are saying that she exceeded what she was supposed to be doing and was able to do. And now she's facing probably 2 actions in front of the Supreme Court in the middle of this trial, and all this conflicting stuff going on with these lawyers. So 3-ring circus is a comment here. And yes. Yeah. And that's not how it should be. The judge shouldn't be the story. The attorney shouldn't be the story. Shenanigans shouldn't be the story. Eventually the facts should be the story. And that's what we used to discuss on it, and what ultimately we might see at trial, and what you could glean from what has been put out there. It was only a week or two ago, a couple of weeks ago, when you're actually arguing about whether their Odin counter argument actually made sense under the facts or not. And now you're having to argue about who's on the case. And how do you put 12 lawyers in, in the one courtroom and all of this stuff that really doesn't have to do with the facts of the case. All right. So this was, I think, a repeat of something I showed. Somebody says, I think she'll recuse herself under pressure. Hey, maybe and maybe not. I mean, she's pretty fired up about this. That's admitting you're wrong, essentially, at that point. And while I think that might be eventually the right thing to do, I guess we'll see. Is there a process for unfair judges to be removed from office, whether federal or state? Well, I mean, sometimes they're just wrong. And then the process is what's going on here, which is you can have the court correct that. And of course, there is a recusal action and things like that. If she's generally wrong, I don't know what they do up there if they vote for their judges or whatever. There's usually a process that can occur if a judge is doing something terrible to get them off the bench in an emergency situation. And of course, you're free to vote them out too if they are voted. I don't know. I might look it up for the next one because that's an interesting question. But we'll see. Right now, I think more immediately, it's just whether she'll be taken off of this case or not. I don't know how she generally acts. And again, I can't say that they didn't do things that, for sure, I can't say. That warranted her taking action against them. The transcript would be good to hear that, to see that, to read that. So in the abstract, as Kurt said, she might have been right, but you don't have that on the record. It doesn't look that way to me. And so if she makes a bad judgment in one situation that she exceeded her authority X degree, doesn't mean she's bad on every case. So I think they're doing the right thing here, which is saying she should be off of this case, and here's the reasons why and all that. So that's amazing that they are, in fact, elected in Indiana. So see if this affects her popularity when that occurs. And, we'll see what happens, right? So if you're down there in Florida, then you may be paying attention to this Charlie Adelson case where he's alleged to have paid people to murder his brother-in-law or ex-brother-in-law so that his sister could come down to where his family lived, bring the kids when they're in the end of all the drama. And he got on the stand, and I have to say, he did a pretty good job as a defendant testifying, in my opinion. He did a pretty good job handling the prosecutor, and she didn't do as bad a job as I think some people say, but I think it's more that he did a pretty good job of fielding answers. Now, I wasn't buying what he was putting out there, but he wasn't the worst by any means of people to get up and testify on their own behalf. He had an answer for everything, which in itself can be an issue. But, his story is just like when you sit back and look at it, to me, it's like, okay, bro, come on now. I know you got a right to tell me this and see if I'll buy it, but I'm leaving your story on the shelf and I'm looking for something better. It kind of was like they went up there and thought, well, this guy has a bunch of money and if we kill his brother-in-law, he'll have to give us money. But they're fair, right? Because they heard that like they were going to offer $1 million for this guy to, concede. So they knew that these extorters and murderers knew that Charlie was only in that for a third. So when they came to him for extortion, even though they don't know how rich he is or not rich, he says, they say, well, give us $350,000 or you die. So see, right away, the murder extorters are being extremely reasonable because they're only asking him to pay the share that he would have paid to buy off Dan Markell anyway. So right out of the gate, if Charlie doesn't do this, he's being kind of unfair to the extorter murderers because they're not asking for in excess of what he was already willing to contribute. So that's very believable. But then Charlie says, I don't have $350,000 on me. I think he said I have $138,000. So then they're like, well, give us okay, then give us $138,000 now or you die. And it's like, well, they're not really out in the car. I mean, they're not going to be unreasonable about this. These are collection agents, right? I mean, they're business people. They're just extorters and murderers trying to make a living out there, trying to provide a value, a service at the right value for something that you think is a fair price. So they're willing to work with them. So then it's like, okay, give us the money after our representative, Katie, spends the night with you. Okay, we'll let you spend the night with you, but then we want this money or you die. Even though, of course, one of the murderers was the father of her children. So very reasonable, again, on the part of the extorters / murderers to do this. And Charlie's unable to come up with, all the money that they feel is satisfactory, but they say, okay, then we'll give us $3,000 a month. Can you do that? Can you make that work? What payment would put you in this murder today? If you go to buy a car, they're like, well, what can we get? How can we get you in this car today? What payment can you handle? So Charlie, don't think about the overall cost of the murder, think about what you can afford on a monthly basis. And for a fine 400-mile-away murder like this, ecologically done in a Prius, $3,000 is a very fair amount. So can you work with that? And of course, if you can't, you'll die, of course, as we've told you previously. So this is his story, and I am not buying it. I am not buying it. So here's an interesting point here. And let's look back to Delphi. That's why they need cameras in the courtroom for transparency. Yeah, I generally like cameras there too. An interesting thing, of course, as well, is the vast minority of cases here that are shown on or broadcast. We're also in the vast minority of jurisdictions, countries that do it, because most jurisdictions don't do it at all. So I don't buy Charlie's story. I think Charlie, it's not going to work out for you, but we'll see. He's looking for one dummy on the jury, and maybe he'll find one. Yeah. So I'm reading some of the comments about this. Yes, the monthly payment plan. And he said, well, he figured if he didn't pay him all up front, then they wouldn't kill him as long as he was giving him $3,000 a month. He could stay alive. So, yeah, right. Okay, so that's all the murders we've got, I think, for the moment. And let's talk about something else, which I've been doing the past few streams, is trying to end it with something that's not so incredibly bad as people's families being destroyed, murdered, or whatever. And let's look at some more criminal masterminds. Foiled. You know, you're a criminal and you go to the effort to come up with a great plan to get away with it, and you run into a Sherlock Holmes, right? I mean, what are the odds? So here's this guy. His name is Johnny Yates. And he was wanted for battery and a couple other crimes, but things associated with treating somebody poorly. And the police were coming to get him, but Johnny wasn't having that. And he did, as you can see on the screen here, the amazing subterfuge of putting a dry erase board outside with a note on it in a very neat handwriting that says, with golf clubs below it, Johnny Yates does not live here. So when the police show up, they're not even going to ring the doorbell, bro, because as you can plainly see, the person they came to get does not live there, right? But imagine, I mean, look, you can see the disappointment on this guy's face, because somebody in that crowd of police was a true detective. You know, it's kind of an Agatha Christie thing. And the pipe, I should have had the pipe out for this. Potentially, this sign is not true. And even if he doesn't live here, it doesn't mean he isn't here. So the person could technically be telling the truth, and yet Johnny still be on the site. So therefore, our investigation must continue. And they got 4 people to come out, and he didn't come out, and they threw smoke in the house. He didn't come out, but then they ended up finding him, I think, and hiding in some closet or something like that. So it's kind of sad to see it. A guy go to that level of, you know, the mass Ocean's 11 style attempt to get away, and yet foiled by diligent police work. Here's another one too, with a sad ending for somebody who was trying to do the right thing. This guy calls the 911. I'd like to report somebody going down the highway the wrong direction. He didn't say in that call that they're all driving the wrong way, but it turns out that was the case. And we're not in Kansas anymore. This case was in Nebraska. So this person was very rattled when the truck came down the highway the wrong direction, almost creating a head-on collision, was able to tell the police, this is where it happened. Come get this maniac. And when police get there, they find a vehicle indeed going the wrong way down the highway, pull it over, and it's this guy. And they say, do you know why we pulled you over? And he goes, I think I'm going down the highway the wrong way. And the police figure out, are you the guy that called this in? And he said, yeah, I did. I thought I was going the right way, and the other guy wasn't. But I guess he saw more traffic, confessed to the police that, in fact, he called 911 on himself instead of turning his car around. So he's a drunk guy trying to do the right thing, and tells on himself. So a couple of criminal masterminds to end there with. Yeah. Yeah, which criminals lie. And see, of course, this guy, you know, he even called in. So one's tried to fool the police and the other fooled himself. Right. So I would appreciate that for anybody who likes to do it, as I'm a fugitive from the YouTube algorithm. Yeah. So this dude with the whole crypto scam, and how much time will he get? I haven't checked enough, you know, to really look into it, like what are the presumptive sentences and things like that. I think his potential is quite high, but sometimes what they get away with is worth it, I think. Yeah, exactly. Johnny Ace doesn't live here. He just exists. It's barely life. And see, that's the thing. See, that sign could be technically true in so many ways, so many conceptual ways. I could see the officer sitting down, having some coffee, and, what's the real meaning of this sign, right? And eventually concluding that, in fact, he could still be in there and the sign maker telling the truth. And then they were able to nab him. Adelson family to be prosecuted. What's interesting is if Charlie goes down, do they prosecute more people in the Adelson family if that happens? So I think, if I were them, I'd be sweating a little bit. And Delphi, how our system shouldn't proceed. Yeah, I agree. It's not good. So anyway, I think that's the stories for right now. Some of these cases will certainly have some action coming up for sure. And, well, that's it. And I hope everybody has a good weekend. I appreciate you stopping by. And if anything you want me to cover on the next one, just leave me a comment below and I will try to do it. Well, that's it. Thanks. Bye.